All right, paragraph 18 deals with escrow. And so it's got 5 different subparagraphs. So we'll start with 18A, escrow. And it says the escrow agent is not, number 1, a party to this contract and does not have liability for the performance or non-performance of any party to this contract. Okay, which to me just meant, why are we talking about any of this, right? This is not really a party to the contract. This is really just more of an informational, hey, buyer and seller agree that this is the role of this non-binding third party. I don't know. But this is the way that we have it, right? So they're not a party to the contract. They're also, number 2, not liable for interest on the earnest money. And number 3, they're not liable for loss of any earnest money caused by failure of any financial institution in which the earnest money has been deposited unless the financial institution was acting as the escrow agent. Then 18B, expenses. At closing, earnest money must be applied first to any cash down payment, then to buyer's expenses, and any excess refunded to buyer. If no closing occurs, escrow agent may 1, require written release of liability of the escrow agent from all parties, and 2, require payment of the unpaid expenses incurred on behalf of a party. So that might be like a survey or HOA, something like that. And 3, only deduct from the earnest money the amount of unpaid expenses incurred on behalf of the party receiving the earnest money. All right. And then 18C, demand. Upon termination of this contract, either party or the escrow agent may send a release of earnest money to each party, and the parties shall execute counterparts of the release and deliver same to escrow agent. If either party fails to execute the release, either party may make written demand to the escrow agent for the earnest money. If only one party makes a written demand for the earnest money, escrow agent shall promptly provide a copy of the demand to the other party. If escrow agent does not receive written objection to the demand from the other party within 15 days, escrow agent may disperse the earnest money to the party making demand, reduced by the amount of unpaid expenses incurred on behalf of the party receiving the earnest money, and the escrow agent may pay the same to the creditors. If escrow agent complies with the provisions of this paragraph, each party hereby releases escrow agent from all adverse claims related to the dispersal of earnest money. All right, so all that's saying is it's laying out the platform for what if one of the parties just disappears and or won't sign a release of earnest money. This gives the escrow agent some power to release. Now, what this doesn't say is if there is a dispute among the earnest money. If there's a dispute, then it's going to go back to paragraph 15, and that's going to, again, going to potentially have to go to court for it. The escrow agent is likely not going to weigh in and say, hey, we think this party is right and this party is not, because there's just not a lot of cause for them to do it. It's just easier for them to stay out of it. They're not a party to the contract, and so they don't want to weigh in. They're going to make you go to small claims court likely to get a release executed there. So just saying what I see in real life, maybe it won't, maybe it'll go easier for you, but if there is a dispute, it can get tricky on that. All right, paragraph 18D, damages. Any party who wrongfully fails or refuses to assign release acceptable to the escrow agent within 7 days of receipt of the request will be liable to the other party for damages, the earnest money, reasonable attorney fees, and all costs of suit. Okay, I don't know that that's really needed because I feel like it says it in paragraph 17, but okay. And then 18E, notices. Escrow agent's notices will be effective when sent in compliance with paragraph 21. Notice of objection to the demand will be deemed effective upon receipt by the escrow agent. Okay, we're going to talk about paragraph 21 in a minute, but y'all, this right here, this is why you've got to put your client's information in paragraph 21, the notices paragraph. If you don't, or if you put your information in it, now you're a part of this. You're the one who they're giving notices to, and you're the one who's now required to bring your client in and all these things that kick off on your agency relationship with your client. Just put your client's information in paragraph 21. We'll talk about it again, but y'all just put your client's information in paragraph 21. At minimum, an email address. I will tell you, like phone number, address, I'm just not as concerned about. But at minimum, have an email address, because this section could go to that email address if that was what all parties agreed to. All right.